Good evening, ladies and gentlemen. Welcome to Thursday night's seminar. Tonight it's Hot Topics with Richard Silver, and Richard is going to be talking about JCT Liquidated Damages. As always, if you have any questions for Richard, please use the Q&A box in the bottom toolbar, and he will endeavour to answer those at the end for you. As always, if there are any specific questions you don't really wish to raise in an open forum, please feel free to email Richard silver@silverllp.com, and he will happily answer you directly. In the meantime, we will get on with things. Richard, I will hand over to you.
Thank you, Julie. Good evening to all of you. Today we're going to cover liquidated damages. As you'll see from the page before you, my background is in construction. I was both the Chief Surveyor and Construction Director of a number of construction companies. I'm a chartered surveyor and a chartered builder. The reason I say that is it's a terrible admission, but with all the contractors I worked for, not one of the projects that I was involved in ever completed on time. And as a consequence, on all the projects, the issue of liquidated damages was a problem that we had to address. Since moving into the legal arena, it will come as no surprise that many of the disputes that I'm either involved in as a party representative or as an adjudicator, arbitrator, mediator, or anything else, quite often involves assessment of delays and liquidated damages. And indeed, I have acted as expert witness on programming and planning matters and dealt with various disputes in this relation. This is one of my favourite topics. I find it a challenge as to how I can seek to avoid liquidated damages where there are circumstances where I cannot claim extensions of time. So it is one of my favourite topics, and I will hope to try and give you an insight of the nature of problems that can arise when a party is seeking liquidated damages. Quick agenda there. Let's move on to the next slide. Okay. Most main contracts include provisions for liquidated damages. And just to clarify, that is a separate issue to general damages. General damages is where you can recover the actual loss that you incur. And therefore you have to prove it. You have to prove that a party is in breach, that as a consequence of that breach you were delayed and not by other reasons, and there are no concurrent events. You then must show that that loss was incurred. You have to show that that loss was reasonably incurred, foreseeable, that it's directly involved or associated with the event. The list goes on. It is very difficult. And those of you who are contractors with subcontractors will know the difficulty associated in proving the loss, because most subcontracts have provision for general damages. Whilst they may refer to the liquidated damages under the main contract, you claim in additional to those amounts, the amounts of your prelims, other heads of costs. You have to prove it. Liquidated damages, by contrast, is a genuine and reasonable pre-estimate. It's stated in the contract, and it's simple. You finished 6 weeks late. It's £10,000 per week. 6 times 10 is £60,000. Please send check in the post. It's really easy and can be seen to be a huge benefit to the employer. As I'm going to identify in a moment, one of the ways of sort of getting out of paying for damages is to show that the liquidated damages has failed. And that can be a major benefit to the contractor because the employer may have great difficulty in proving their actual loss. I should stress that where the liquidated damages clause has failed, not where it's stated as nil, but where it has failed, the contractor usually will be liable for general damages. But the problem is that the employer will have to prove it. Where it is the fact that the liquidated damages has failed, as it says at the bottom, both time and damages are at large. What that means is you have to prove it. you're saying they failed to complete on time, you have to prove it. You have to show what was a reasonable period of time to complete the works, that they failed to do that, and that the reasons for the delay are for events for which they're culpable. Then going to prove your damages, you need to show that but for the delay, you would not have incurred the loss, the damages you're seeking. It can be difficult. So, because the courts see it, that there is a major benefit to the employer of having liquidated damages, where the contract fails for one reason or another, the employer will lose their entitlement. And one of the main circumstances where an employer will lose their entitlement is where the mechanism for extension of time has failed. Let's just run through a very simple scenario. Let's say, for argument, that we have a contract that has no provisions for extension of time. And we've got a provision that says if you fail to complete by the completion date, the damages are £10,000. I then don't give you possession of the site. I don't give you all the information to carry out the works, and I cause no end of delays in the execution. So as a result, you finish 50 weeks late, and I say, well, it's very simple. Damages are £10,000, 50 times 10 is 500,000. Please pay the money directly into my bank account. Now, simple situation is under those circumstances, the provisions under the contract will fail. The reason for that is that the damages will be a penalty. In other words, I'm incurring all this money in liquidated damages, not because of your breach, but because of my own. And that is a penalty clause. So to overcome that problem, most contracts provide for extensions of time. And what they must do is provide for extensions of time for events for which I, as the employing party, are culpable. So they have to include, for example, late access, variations, late information. They do not, however, have to deal with things that are not my fault. For example, exceptionally adverse weather conditions, force majeure, and before you ask about it, the coronavirus. Anything that is not my fault, I don't have to give you an extension of time unless the contract provides for it. Now, under the JCT, because it is produced by the Joint Contract Tribunal, they have put in certain events that they think it is only fair, not legal, but it is fair that the employer should take responsibility for, including force majeure and exceptionally adverse weather conditions. But you can delete them, and it will not render either time or damages at large. But it is not as simple as that, because the damages still can fail in a number of circumstances. The easiest way of explaining this is ultimately you say the other parties failed to complete on time and that they owe you large amounts of money. It's my experience that when you ask for money, quite often people don't want to pay it. And as a consequence, you have to go off and seek to recover it to the courts, adjudication, arbitration, so on and so forth. And what you need to do is to evidence and prove to the third party that you're entitled to the money. Now, where you're looking for liquidated damages, you are saying that they've failed to complete certain works by a certain date. So the first thing you need to say is, what works needed to be completed? Now, it seems obvious. Well, it's the works, isn't it? But sometimes there can be considerable doubt and uncertainty about what the works actually comprise. And where there is a lack of certainty, the clause will fail. And the easiest example I can give you is where the contract, the JCT form, includes 4 sections. So what work is comprised within which section? Let's say we're doing a large construction of 50 houses. Which section is all the mains drainage in? Which section is the roads in? If you're doing a big building and you've broken the works into sections, but the boiler is in one section, or the works that rely upon the boiler is in another section, you can see the problem. So number one is you need to identify what works need to be completed. And I do find, particularly where there is sectional completion, that it is not as clear as maybe it ought to be made. You need to be able to establish clearly what works are going to be completed. The next problem I see is, on the same heading, is the description. I've seen the situation where they say you have to complete certain flats, but you look at the employer's requirements, the term flat isn't defined. Where does the common areas come into it? What works is within what section? Is this part of a flat or otherwise? Again, the definitions used are not clear. So straight away, number one is make sure you identify exactly what needs to be completed. And thereby, if that element is not completed, you can claim the damages flowing therefrom. The next point is what are the damages? Now, quite often people say something like this, £10 per flat. But the sections aren't a flat, the sections are 10 flats. We've got a conflict between what is described as the damages and what is described as the works that need to be completed. So what I would suggest to you is very simply is that if you've got the works, then the damages should be for the works. If it's sections, then the damages should be £5,000 per week for the section. Do not differentiate between what is required to be completed and what the damages are assessed as. So the damages as stipulated should always be for the works, or where there's sections, for the sections. The next problem is, when are the damages to run from? Sounds obvious. The damages should run from the date for completion or as extended. But I see people putting in provisions that say you will have a 2-week damages-free period. And what they're doing is creating a potential problem, because people like me try and find a situation where that clause doesn't work. And as soon as it becomes uncertain, it will fail. So it should be simple. The damages flow from the date form for the completion of the section or the works, or such date as is extended by. Should be simple. And then, when do the damages come to an end? Again, sounds obvious, when the works are completed. But again, I see lots of other things that are not as clear as that. And I would add a particular problem. What happens if there is a termination? They won't complete them. So does it run from the date that the contract was terminated? Or does it run to the date when the works were actually completed by another party? We're creating uncertainty. And there is a case on this. It's called the triple point case. And albeit that is an area of law that has gone backwards and forwards, the current position is that where the contract clearly provides that the damages are to flow from the date that the works are completed by the contractor and their employment is terminated, they will never complete the works. So therefore, damages in theory would run forever. And of course, the damages then are rendered at large. So do be careful. The next one is to do with proportioning down, and it happens a lot where partial possession is taken. Now, damages must be a genuine and reasonable pre-estimate. So if you've put £5,000 per week or part of for the works, let's just say for 2 houses, and you take one of them, well, the damages can't be the same for one as they would be for 2, so you need to proportion down. You therefore need to have an appropriate provision in the contract for proportioning down. And it may say, for example, that you proportion it down based upon the value of the works as completed over the value of the works for the section or for the works. But where you've got the section and the section value is not included, you don't have one figure to include in the mathematical calculation. We have uncertainty, and it's all failed again. So number one is you have to have a proportioning down clause, and then you must have all the information to insert into the formula appropriate for the proportioning down. And I've been involved in projects where that is exactly what was missing. And hence, when acting for a contractor, I was able to avoid the application of liquidated damages. The final one we've already covered is you must have provision for the delay events. But be careful, I'll give you an example. One I've dealt with on loads and loads of occasions. Deferred possession. Now, those of you who are involved with the JCT form will only be too aware that the contract provides for deferred possession and gives the provision for an extension of time where there is such deferment. But if you have a look in the contract, it says the period of deferment, if included, is up to 6 weeks. So if you include the provision for deferment, it's for 6 weeks. What happens if you defer for 7? Well, simply, you can only award an extension of time for 6. You're going to be claiming damages for 7. So therefore, 1 week you're claiming for the contractors, well, for your failure, not the contractors. That becomes a penalty clause and the whole lot fails. So be careful. It is not uncommon for liquidated damages to fail. And indeed, when I'm involved in disputes, that's one of the first things I'm going to be looking for. I'm going to be looking in the contract particulars. I'm going to be looking if there are sections of the works. I'll be looking at trying to determine what works are falling within which section. I'll be looking at how the damages are stipulated. I'll be looking to see if there's anything I can find that makes the damages fail. So be careful. Now, the first case that dealt with liquidated damages is Dunlop versus the New Garage. And it's very simple. It says that liquidated damages must be a genuine and reasonable pre-estimate of the loss. Let's just address that. Let's just say, for example, that there's £5,000 worth of damages per week or part thereof in the contract, but the employer only actually incurs £1.50. Can you get out the damages clause? The simple answer is no. The fact that the employer doesn't incur it is irrelevant. The simple question is was it a genuine and reasonable pre-estimate at the time one was entered into the contract? If the damages was £1,000 and the employer liquidated damages of £1,000, but the employer says, oh, I've actually incurred 10,000, can you pay me that? You'd say, no, it's 1,000, it's capped. So it is not what is actually incurred that is relevant, it is whether it is a genuine and reasonable pre-estimate. As the middle paragraph says, it is read at the time of the making of the contract. It is forecast. It recognises that it is in arguably both parties, but at the least the employer's benefit in making an assessment at the start. So it is capped. And indeed, quite often in certain projects, it's very difficult to make an assessment or prove a loss. So therefore, there is a huge benefit in having a genuine and reasonable pre-estimate. And one of the cases, for example, deals with a submarine prior to, and I think it was, the First World War. Obviously, vitally important the submarine is completed, but how would you assess your loss? And the court said, well, that's exactly why liquidated damage is reasonable, because you couldn't prove it, but it's obviously extremely important to make such an assessment. So far as whether it's a genuine and reasonable pre-estimate, it will be seen to be a penalty clause if the sum stipulated is extravagant. It is so much more than can ever have been foreseen. If that can be shown, then the damages clause will fail. So even if the employer stipulated it and written in a contract, and the contractor has signed it, and they've all agreed to it, if it can be shown as being extravagant, unreasonable, unconscionable, far greater than could ever have been perceived, then it is likely that the clause will be seen as a penalty clause. However, there is some new case law on this, and they have recognised in certain circumstances one must consider factors other than the reasonable loss and the party's own interest. We're going to come to that in a moment. Dealing with the clause Alfred McAlpine, in assessing the loss, what they are identifying is the difference between the amount stipulated and the actual amount that could reasonably be foreseen. It must be substantial. The reason for that is it is obvious that when trying to make an assessment at the time of the contract is not easy. It's not always possible to foresee what the actual loss will be. And therefore, this case shows that it has to be substantially wrong for the clause to fail. This is an interesting case, which I did find somewhat surprising, is that in this case, the party had agreed expressly to exclude liquidated damages. And the court therefore decided that in so doing, they'd also agreed to exclude general damages. We're going to deal with a case called Temlot versus Errol, where the liquidated damages was actually stipulated as nil. And as a consequence, not only could the employer not claim liquidated damages, but they were also seen as agreeing to there being no general damages. And indeed, I've had many disputes on this very point. Case that is of interest is this one, which is a fairly recent case, where they identified that the operation of a commercial justification might save the liquidated damages, where the liquidated damages is seen as being slightly high. And it concerned parking. And what happened was a person is meant to park their car and pay £5, say. Because they didn't pay or went over their allotted time, the result was that they got a penalty clause, a damages clause of £10. But hold on a moment, that's far higher than the potential loss. They were only meant to be paying £5 as it was. And what they identified in this case was there was a commercial justification in seeking to ensure that people paid for their car parking. As I've mentioned, there is substantial benefit for the employer to have liquidated damages. As far as the courts are concerned, it is the employer's major benefit, and therefore where it is seen that there is some failure, the damages are rendered at large. But it is only right to impress upon you that the liquidated damages does operate as a limit on the employer's claim for damages. And whilst there is no clear case law, there is obiter, in other words, the courts gave an indication, albeit they didn't judge, that where the liquidated damages fails, the employer can only seek damages, general damages, up to the amount of the liquidated damages. It was seen unfair and unreasonable that where the liquidated damages clause failed, that the employer could benefit from that and actually recover more damages. We're now going to turn to the standard form, and this is common within the JCT forms in looking at what needs to be put in place in order to claim liquidated damages. And the starting point is that there must be issued a notice of non-completion. Now, do be aware, and I've only had this before me recently, the employer, employer's agent, the contract administrator doesn't have to issue a non-completion certificate. So where the contractor has failed to complete by the completion date, there's arguments of extension of time. Contract administrator doesn't have to issue a non-completion certificate. The only reason for issuing a non-completion certificate is as a precondition to recovering liquidated damages. In other words, if you have not issued a non-completion certificate, you cannot claim liquidated damages. So that's why you have to issue it, but you do not have to issue it 1 minute after the date for completion has not been met. Basically, the contract administrator can issue a non-completion certificate at any time when it is authorised to do so. And when looking at that, basically the contract administrator has such authorisation up to the final certificate. Up to the final certificate, the contract administrator is still administrating the contract, and therefore he can issue the non-completion certificate. As soon as he has completed his duties, his right has gone. And hence, if that happens, the employer would not be able to recover any liquidated damages. So the first precondition to liquidated damages is a non-completion certificate. The next thing is the employer must write to the contractor and state that he requires liquidated damages in accordance with the 2 clauses. So that is a second notice. The third is where the employer is seeking to set off against amounts otherwise due, he must also issue a payless notice. I'm sure you're all aware about the issue of payless notices, but quite clearly where you're seeking to set off sums, the employer must issue a payless notice. I should stress, however, that the payless notice is only required where you're seeking to set off. Where you are going to seek payment from the contractor of the liquidated damages, then you don't need to have a payless notice. But as I'm sure you're all aware, when you ask for the payment of liquidated damages, it's not always so easy to get the contractor to pay it. It is far, far easier to set off such sums against amounts otherwise due. The next thing concerns extensions of time. Under the JCT forms, where there has been the issue of a non-completion certificate, but subsequently there is an award of an extension of time, the effect of the award of an extension of time is to cancel the previous non-completion certificate. The consequence of that is as soon as that non-completion certificate is cancelled, the employer effectively has to repay the relevant damages. So what the employer contract administrator has to do is to issue another non-completion certificate. So let's just make this very clear. Each and every time an extension of time is awarded, be it by the contract administrator or an adjudicator, a new non-completion certificate has to be issued. And where there is the cancellation of a non-completion certificate, any damages that have been deducted have to be repaid. One of the favourite clauses or favourite cases I have is Brahmal and Logdon versus Sheffield Council. Now, there has been in recent years quite a bit of press about this somewhat old case and the views that maybe it has or it was wrongly decided. And there is a move by the courts to the effect that liquidated damages will not so easily be rendered at large. Now, whilst that is an indication, at the moment, this is still good law and the situation hasn't changed. Now, the situation in Brahmal and Ogden was very simple. The contract provided for the execution or the construction of a number of units, and there was only one completion date. But the damages were stipulated as, let's just say, £6 per week or part thereof per flat. It didn't say for the works, it said per flat. And what happened was that Sheffield City Council took partial possession of elements of the works. And the contract provided for the proportioning down of the damages. And it set down a formula. It said that what you did was you took the value of the works taken into possession over the value of the works and times it by the liquidated damages clause. But the problem is that formula didn't work. What you had to do was times it by the liquidated damages times by the flats. There was an inconsistency between the way the damages were stipulated and the way the proportioning down on partial possession occurred. And as a consequence, it was considered that the clause should be construed contra preferentum, against the party seeking to rely upon it, and hence fouled. Time and damages were rendered at large at the time partial possession was taken. Now, I've been involved in a number of disputes since 1983 and Brahmal Logdon, where people have stipulated damages as per flat or per house rather than per works, and have found partial possession has been taken, and I've got out of liquidated damages for the contractor. It will not surprise me of those that you are listening now are all running off to your local chest of drawers, pulling out the contracts and looking to see if you have this situation, because it is still occurring. I should also add, in regards to the NEC 1, when first issued, had no proportioning down clause at all. And as a consequence, damages were rendered at large where partial possession occurred. You will also be aware that in the NEC first edition, there was no compensation event for any other breach by the employer. The reason why that was brought into later editions was to prevent time being rendered at large. This was sort of a saviour clause that where none of the other compensation events allowed, this allowed the employer to grant an extension of time where they were culpable, thereby avoiding time and damages rendered at large. Next case there is Temloc versus Errol. In this situation, the contract provided that damages, liquidated damages, were nil. I've had it before. The effect of this is that not only liquidated damages are nil, but general damages are nil too. Now, the simple situation is, when there is an issue of delay, you have a choice. You can either seek liquidated damages or general damages. You can't claim both. In Temloc Errol, there was clearly provisions for liquidated damages. So therefore, general damages were excluded. And as far as the liquidated damages were concerned, they were nil. They were not deleted, they were not omitted, they were included in the contract as nil, and therefore the employer could not claim general damages. We dealt with Chatham a little bit earlier. It's basically the same situation as Temlot versus Errol. We've mentioned earlier on this case, so we'll jump on. Now, dealing specifically with the amount of damages, we have stated that they must be a genuine and reasonable pre-estimate. They must be seen to be reasonable, except for where there is some commercial justification. Now, it is quite often the case that there will be multiple liquidated damages clauses, clauses for, let's say, 10 separate sections, or maybe 15 key dates, or 100 milestones. There could be loads of different things which each apply liquidated damages. And what you must see is that the amount of damages as compared with the events is reasonable when comparing one against the other. So where you can see there is a damages against one item, which is for very little work, yet there is damages for a same sum for huge amounts of work, that may well point to a penalty. It must be seen as a genuine and reasonable pre-estimate. Where there is an obligation, let's say, to pay £5 by Friday, it is difficult to say that failure to pay the £5 by Friday results in an entitlement to £10. Very difficult to explain how that could ever be seen reasonable or commercially justified. Again, quite obvious. I am aware that it is not uncommon with regards to particularly local authorities for them to include a calculation as to how the damages are to be worked out. I would strongly urge you, if you do have that nature of formula, keep your calculations to show that at the time you produced it, it was reasonable. But I do find that sometimes there is errors in such calculations. And if those backup information is provided, and you can show there has been a fundamental failure in the formula or the figures brought forward, these may indeed prove that the damages as calculated at the time was not genuine and reasonable. So do be careful. I have seen this clause quite a lot in contracts, and it does assist, but it will not overcome on itself failures. What it is, a clause that simply says the parties agree at the start that the sum is a genuine pre-estimate of the loss and not a penalty. But if I put that clause in and I say, if you fail to pay me £5 on Friday, you owe me £1,000, this clause will not save you. It will not help, because it is clear that the amount stipulated was not a genuine and reasonable pre-estimate. Now, as far as proving damages, as I've said, this is very difficult. You will need to show that in the first instance, what was the date for completion? Now, whilst you can rely on the original contract completion date and programs issued, you will need to show that that period is reasonable because time has been rendered at large. Having proved that time for the completion was reasonable, you'll then need to show that they failed to complete by that date and that it is for events for which you're culpable. What you then need to prove is what is the loss caused by that event, including foreseeability, dealing with concurrent delays and other issues. So I do suggest to you there is a substantial benefit in having liquidated damages. And indeed, for those of you who are contractors, I would strongly suggest that you have liquidated damages in your contract with your subcontractors rather than general damages. Now, this quite often sparks a lot of debate. People say, well, that's no good because we don't know what our loss will be and our loss could be far greater. And what I say to you is I've worked for many contractors in seeking to recover general damages from their subcontractors. And my answer is you're not very successful. It's very difficult to prove that they were on the critical path, that they caused you to incur the loss that you've incurred. They bring up arguments of concurrent delays and other problems, and this was not your reasonable costs, and this is what you would have incurred in any event. Whereas to simply say you finished 3 weeks late, it's £5,000 per week, so therefore 3 times 5 is 15, would be much simpler. So I would, in my opinion, advise contractors with their subcontractors to have liquidated damages rather than general damages. And it comes as no surprise that under most main contracts, they nearly always have liquidated damages. So where does that leave us? Well, just because you have liquidated damages in the contract does not necessarily mean you'll be able to recover them when the contractor finishes late. The first thing you need to ensure is that time isn't rendered at large for an event for which you're culpable. You need to show that the completion date, the reason why the contractor failed to complete by the completion date was not your fault. So if you can award an extension of time for anything that's your fault, then you're safe. So number one, ensure that you have proper extension of time clauses. Number two, make sure that the damages can be calculated. You need to know what the damages apply to. What works need to be completed and by when. Make sure that the damages stipulated can be easily reflected against the works that are undertaken. Make sure if you're going to proportionally reduce because of partial possession that the clauses work. Make sure you have clear evidence when the works were actually completed. The list goes on as we've gone through. If I haven't worried you all, hopefully there are a few questions. Julie, any questions?
There are indeed some questions. Someone's asking, can other costs be claimed as well as the prescribed liquidated damages?
The answer to that one is obvious, yes and no. The situation is you cannot claim for general damages for delay and liquidated damages for delay. But you might include a claim for damages for delay, liquidated damages, but damages for the failure of the works to perform or for other events. But so far as late completion is concerned, you can only claim once. It's either liquidated damages or general damages.
Okay. Someone else is asking, will COVID-19 have any influence on the calculation of liquidated damages for projects?
Of course, the answer is again, yes and no. The starting point is it will only have an impact to the extent a party is entitled to an extension of time because of it. So if the contract either doesn't provide for the entitlement to an extension of time because of COVID, then it will have no impact. As I've said, COVID is not the employer's fault, and therefore the contract doesn't have to include provisions for extension of time for delays associated with it. There is much debate as to whether it is an act of force majeure or other potential clauses. And that will all depend upon the wording of the particular clause and also when the parties entered into the contract. Clearly, a contractor's entitlement to claim extension of time is going to be far more difficult where the contract was entered into after COVID was known of. It can't be seen really as a force majeure, an act that neither party knew of when they did know about it when they entered into the contract. So the only impact COVID will have is to reduce damages because of an award of extension of time where the contractor has such an entitlement.
Okay. Someone else is saying, is it not the case that if a non-completion certificate is not issued when the completion date has elapsed, that the contract is at large?
No. There is a common mistaken understanding of what time at large means. The one that people often say is I've claimed an extension of time of 6 weeks, I'm entitled to it, you haven't awarded it, time's at large. And that is wrong. Time is at large only when the provisions for extension of time fail. The fact that you have not been awarded an extension of time where you think you're entitled to it doesn't mean the contract has failed. What it means is simply the person who is awarding you it hasn't administered it properly. But the contract includes provisions for adjudication and potentially arbitration and litigation. And the adjudicator, arbitrator, or the judge has the power to award you the extension of time, and hence the mechanism hasn't failed and damages are not rendered at large. So far as the issue of a non-completion certificate is concerned, all that is a precondition to have and take liquidated damages. It has no impact upon whether either time or damages is at large.
Okay. And the last one I've got so far, someone set us a hypothetical scenario.
Oh, they have a
in a scenario whereby the contractor suspended the works for non-payment and the contract was terminated. Subsequently, the contractor issued proceedings in respect of unpaid invoices and the employer counterclaimed for liquidated damages. Based on this scenario, is the employer entitled to counterclaim for liquidated damages for work that was never completed? And what is the likely outcome if we were to refer this dispute to adjudication?
I'll deal with the second bit. If you're going to refer it to adjudication, preferably to me, and I will charge a fee. But I'm not sure that was the question that was being put. I am guessing this is someone's LLB or MSc question for their exam, so I've got to be careful. But I would refer the particular person to what is called the triple point case. And I did refer it into the notes briefly, but basically the situation is that in certain circumstances where there has been a termination by the employer, the liquidated damages clause will fail. And I think that's what the question is referring to. Now, the situation is in the triple point case, it doesn't say that the liquidated damages clause will always fail, but will depend upon how the liquidated damages clause in the contract is stated. And where by reason of the termination clause, the damages in theory could flow on forever or something like that, the damages will fail. So to give you an example, where it says that the liquidated damages will apply from the date for completion to the date when the contractor actually completes the works, yet the contractor will never complete the works because the contract has been terminated, there is a distinct possibility that the liquidated damages will fail.
Okay, thank you very much for that. That seems to be all the questions for this evening. So thank you for an interesting presentation on the JCT liquidated damages. And we look forward to seeing you again next week where we're talking about smash and grab adjudications. If anyone would like to book on for that, drop us an email to seminars@silverllp.com for another Hot Topics with Richard Silver. In the meantime, thank you, Richard, for your time. Thank you, everyone, for joining us. And we look forward to seeing you again soon. Have a safe evening, everyone. Thank you, Richard.
Oh, thank you.